Jerry Mason, the Kickin lawyer. So you hear me a lot of times refer to burdens of proof. So if you ever see old Lady Justice, I got a statue over in here somewhere. You ever see Lady Justice and she's holding the scales? One hand, she's blind and she's got a sword. Well, the scales is supposed to detail or at least be an example of the weight of evidence, right? So the burdens of proof, depending on what court you're in. Well, in criminal court, there's really three basic burdens of proof we deal with. Sometimes in evidentiary hearings, there's a civil burden, but for the most part, the cop level is going to be whether they have reasonable suspicion or probable cause. Now, probable cause is necessary for arrests, search warrants, things like that. So the cops usually focus on the burden of proof of probable cause. So what is it? Well, the actual written definition is legal standard that requires law enforcement to have a reasonable belief supported by facts and circumstances that a crime has been, is being, or about to be committed. That's the legal term. So what does that mean? It means that it's possible that somebody is about to, did, or is going to commit a crime, and they have to have facts and circumstances that support that. Now, we often say it's probable cause to stop a car if like a taillight's out, but really if they have evidence the taillight's out, it's arguably that's beyond a reasonable doubt that they're violating that law, the light law, right? Which is the highest burden of proof. So when you go to jury trials, beyond a reasonable doubt is the highest burden of proof in our judicial system. And I've said this before, if people really understood how high that is, there'd probably be a lot more not guilty verdicts at trial, because beyond a reasonable doubt, it's very high. But anyway, a little insight into the burdens of proof and sort of what, as a criminal defense lawyer, I focus on.